Happy Friday night live, everybody. It's 4th of July weekend. We have a ton to talk about. I am going to go through a quick weekly round. Well, I always say it's quick. I always feel like a liar. I'm going to go through a quick weekly roundup talking about just a few topics. I had asked the members what they were interested in, so I definitely culled it towards what the members had said in our chat that they were interested in. Then we are going to talk about some Britney stuff, some Girardi stuff. If you follow me on Twitter, you'll see that I am waiting for a Girardi document to be filed that was due at 4 p.m. Pacific time today. Normally, Pacer updates pretty fast, so I'm hoping that during the stream it will update because I'm very curious. I'm very curious. There's a new court order in the Britney case. There's a lot to talk about. Like the nothing is slowing down. The law is not slowing down at all. It's so good to see you. Let's just get rolling. We got a lot. I've got some booch. I'm here outside of Nashville, and it's good to see everybody coming in. Let's get into Friday Night Live. Let's roll it. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. It is 4th of July weekend. It was just Canada Day. It's been a very busy week. We have a very international audience. Hello, everybody coming in. It's just been a wild week. I know. And for everyone that loves YouTube as much as I love YouTube, y'all know that before being a YouTube creator, I am a YouTube fan. I'm a very long YouTube fan. I watch a lot of YouTube. So I know there's a lot of YouTube tea going on. I know. We'll talk about it towards the end. We have a lot of law to talk about before we get to James Charles coming back and taking down his video and all that other stuff. We've streamed so much this week that if you missed anything, there's a bunch of content on the channel right now. So be sure to show it some love. I've seen all of you checking out the Emily Show podcast because I've seen the rankings for the podcast around the world. It actually is doing very well in Brazil. Hello, Brazil. So I've seen the international charts for the podcast. So I know that you guys are checking that out too. It's so fun to see where everybody's coming in from. Hello, Arizona. Hello, everybody. So it's good to see everybody. Hello. So thank you all for coming in, letting me know where you're at. I'm still recovering from being sick, to be honest. This is probably the best I've sounded in like 2 weeks. Hello, fellow Nashvilleian. Today's weather, by the way, so glorious. Today's weather outside of Nashville has been glorious. Like the air is cool, but it's still warm. It just feels so nice. No, I'm not talking about Jen Shaw tonight. Unless she's done something on social media that I have not seen. Jen Shaw filed a very long defense motion that I'm going to do a deep dive on, but the government's motion is due in a few days. So I'm going to combine the two so we can do a deep dive between Jen Shaw's motion and the government's motion. I saw a super chat come in and I can't pull it up. So Carolyn, thank you for the super chat, super sticker. I appreciate it. Good to see everybody. Am I sure I don't have COVID? I did not go do a COVID test. I didn't realize that. Look, I have been very deep in the law stuff. I did not go do a test for Delta variant. If I have had a sinus infection, I don't know if that's one of the things with Delta variant. I called my doctor's office. I am COVID vaccinated. And they're like, it sounds like a sinus infection. I'm like, it feels like a sinus infection, which is actually going around in my area. So that's what's going on. Allison McNeely, yes, I'm going to address that in the weekly roundup, not in great depth and detail because it's really freaking dark. So I will address it a little bit for sure. Jay Thompson said, I have appreciated your coverage and breakdown of the Cosby situation and Britney. Sheltonham, look. I can't pronounce things. I appreciate it. I'm going to get it wrong. So, Cheltenham is I know. I got a bunch of it. So Cheltenham. Anyway, we are not out and around with other people, so I was not super worried about going and getting tested after I talked to my doctor's office. So anyway, that is what it is. Hello from Argentina. Been a time. It's been months since I last saw my fiance. He's been recovering from COVID. I miss him so much. Good Friday, everybody. Thank you for the super chat. I hope that your fiance is feeling better. And I know some of you are having chats about what's going on. I trust my doc. I'm not around other people, so I'm absolutely taking those precautions. So Amy's like, I thought I had a sinus infection. It was COVID. I mean, yes. And Laura said it's Cheltenham in the UK. Well, see, I just am, I'm not able to pronounce things. That's the truth. Someone asked if I was putting new color in the hair. I think at our next kind of subscriber milestone, I will change up the color a little bit. So I might do a galaxy kind of take on it, but I really love the purple. I really do. So the Paw Nerds, yes, both of them are in there. They are squished up together. I shared a bitch of them. I shared a bit of them on Instagram today. So if you follow me on Instagram, they are in my IG stories because they have been very helpful as I'm getting ready for the show, sitting there and being adorable. But at least they're sitting over there. So that's good. Crafty said hello from Olympia, Washington. It's finally not 100 degrees here. Yeah, I know that. Brian was showing me video. Dr. B was showing me video of Lake Tahoe yesterday where the bears were just literally like coming out of the woods like little cubs to get into the lake because it's so hot there. And I know that people are getting smacked with a heat wave. We actually got a little bit of cool air today. So I was very happy for it. I'm trying to be like, I'm trying to move over so y'all can see the Paw Nerds better. There we go. I move around so much in my chair when I film that I'm always somewhere different. And I moved Lady Justice. I felt like she needed a better spot because we've talked about her so much lately. We should absolutely get into the weekly roundup. I'm going to let you guys keep saying hello. I'm going to do weekly roundup. I'm going to check back in on the chat. And then I am going to go to the new court orders in the Britney case, and then I will double back to Pacer and see if we have a new motion in the Girardi case, because there's some stuff that's happened, but I'm waiting on that motion. Corey, 150K Galaxy hair. I could do Galaxy because I'm so purple, and we're at 138. So thank you to all the new law nerds. You guys can go ahead and put a 1 in the chat so all the law nerds can welcome you. If this is your first live stream, if it's the first time catching us live, go ahead and put a 1 so everybody can be like, hey there, good to see you. Because it's so fun seeing new people discovering the live streams and being able to make them. Let's get into the weekly roundup. Weekly roundup. I always feel like I should be like roundup. Like, I don't know who I think I am, but yeah, it should be a roundup. During that little video clip, I'm supposed to shift over my screen so I can share the story that I'm talking about. But I didn't. First story comes to us with regard to Rockefeller Records and Jay-Z regarding Damon Dash. I touched on this maybe Tuesday, maybe last Friday. I'm fascinated by this case. Look, I am absolutely fascinated by this case. I hope that you're also interested. But Damon Dash is one of 3 founders of Rockefeller Records, which is the record label of Jay-Z, and he's trying to sell an NFT in his part of the copyrights with regards to Jay-Z's first album, not first album, I think it was just it was his first album on Rockefeller Records, and it was his Reasonable Doubt album. And so they're trying to sell an NFT in his 1/3 of his copyrights. And as that went up for sale and as that became public, Rockefeller Records was like, what? No. Stop right there. Thank you very much. I need somebody. Yes, we're singing Spice Girls while talking about Jay-Z. It's just, that's what's happening. And the court issued this order of today. Today's the 2nd, right? Pacer does update to the 2nd. I'm just waiting for the other case to update. This was filed today. This is no longer a stipulated and proposed order. The court lined out proposed. The court signed this order, and this is a injunction from engaging in any NFT sales or auctions until this lawsuit is resolved. This is a win for Rockefeller, because if there was not a good probability that Rockefeller was going to succeed on the merits, then this type of relief would not be appropriate. So this is an initial win of the court saying, you've got a point. Like, we see what you're saying. We hear what you're putting down, and we think you could win this. And we think you could be very harmed if we allowed, we can't put the shit back in the horse, is really what these types of injunctions are for. These types of injunctions are to stop something from happening before the lawsuit resolves. We see this in the Haley Page case. We saw this asked for in the Satan Shoes Nike case, but at that point, the shit was already out of the horse, and they're like, we sold them. Sorry, y'all. It's hereby stipulated and agreed that pending the final resolution of this action, Dash and all those in active concert with him and all persons having notice of this order, by personal service or otherwise, are restrained and enjoined from altering in any way, selling, assigning, pledging, encumbering, contracting with regard to, or in any way disposing of property interest in reasonable doubt, the album in question, including its copyright, including through any means such as auctioning an NFT reflecting, referring, or directing to such interest, provided, however, that nothing in this stipulation shall prevent Dash from selling, assigning, pledging, encumbering, contracting with regard to, or in any way disposing of his 1/3 ownership in RAF Inc. to the extent that it may otherwise be transferred in compliance with the laws. So they're not saying you can't sell your interest in RAF. We're selling that you can't sell an NFT in this album, but you could sell your ownership interest in RAF Inc. I wonder if this paves the way for the other owners of Rockefeller to try to resolve this by buying him out. I feel like this means, hey, you can sell your 1/3 interest in accordance with the law, and that's going to also be in accordance with whatever their corporate documents say with how this can be disposed of. So I think this paves the way for them to buy him out if he, needs the money, wants to get out, doesn't want to continue receiving residuals or whatever. Accordingly, it's hereby ordered that pending final resolution of this action, Dash and all those, in concert with him are restrained and enjoined from selling an NFT, and signed by the judge. So there was a temporary order issued. This is the permanent order issued until the end of this case. So I think, and I don't normally call it, I'm getting a little more sassy with calling my opinions on some of these cases that are large. I think that now there's an injunction in it and there's no way he can sell this NFT. They may actually be able to successfully buy him out if that's what he wants. It gives him impetus to do so. It gives both parties some leverage because Rockefeller can run or try to run Dash out of money. That's not in anybody's best interest. His ownership interest is more valuable before that happens. So it seems like this puts the parties in a really good position to just come together and resolve this shit, because now the thing he wanted to do, he can't do till this is over. Lawsuits can take years and be very expensive. So he has a reason to say, okay, fine, just fucking buy my interest then. Or to offer that for sale, because it clearly says he's allowed to. We've got to talk about defamation for just a minute. So let's talk about defamation in the Supreme Court. Nick Rekieta has a great video breaking this down. I ended up doing a surprise stream. It didn't even go out to the text group. I didn't even know I was going to be streaming. Eric Hunley was live with Nick Rekieta and Nate the Lawyer and Good Logic. And they started joking about, let's talk about the hot topic in the day. And I was prepping for tonight and I had some stuff I was reading. And so I just put in the chat in a sassy way, hashtag free Britney, because that's my hot topic of the day this week. And so they started talking about Britney. And then I'm in the chat and I'm like, no, this, no, that. And so Eric Huntley's like, why don't you just pop into the stream? And I was like, you're right. Let's talk about Britney. So I ended up popping into Eric Hunley's stream, and then Viva Fry popped in as well. And we talked about this a little bit. I don't know when Eric Hunley ended the stream because we talked for like almost 40 minutes, I think, after the stream ended. And that's when I think this conversation happened. I don't know if this came up on stream, but it was very interesting to me. We talk a lot about defamation on this channel. The laws regarding defamation are due for some court intervention. Like, you can't just defame people. You can't just slander people. Like, you can't just say whatever on the internet and think that it's not going to be a problem. So let's talk about defamation real quick. The Supreme Court has indicated, well, two justices have indicated, Gorsuch and Thomas have indicated that they want to take a look at New York Times versus Sullivan. New York Times versus Sullivan brings us the test that makes a lot of public figure defamation hard to prove. Defamation per se being different, but a lot of the public figure defamation where you have to prove that malice standard can make defamation very difficult. So the court said in their dissent to not taking up a different case, Gorsuch wrote today that since 1964, our nation's media landscape have shifted in ways few could have foreseen. No shit. Twitter and every other social media platform. Like, you can reach. We saw this week. I was so mad about this week. I was so pissed about the Britney headline, and I shouldn't be mad when the media misleads people because everybody's responsible for reading beyond the headline, and personal responsibility, yes, and free speech and the media, but I think there should be some responsibility. And the headline, like, judge denies Britney after impassioned court plea and keeps her father. I'm like, that's not exactly what happened. Like, yes, this order was signed on June 30th, but this order was made by the court. The order was made in November. So the paperwork just didn't get signed to formalize it, but that the order was made. There was no reconsideration. The court wasn't going to overrule that order. That was a standing order that the paperwork just needed to be done on. It's not new, and it's not as if the media, I think, made it sound like the court listened to Britney and went, yeah, we don't fucking care. And that's not what happened. This was an old ruling that was just memorialized in the paperwork. So I was very annoyed by these headlines, but you see how fast a wrong headline can gain traction and just go, whoosh. And that is so different than when the only way to really get this information was either by radio, daily. We didn't have a 24-hour news cycle. And so it's very interesting to me to see, the court acknowledging that since 1964, our nation's media landscape has shifted in ways few could have foreseen. He added that thanks to revolutions in technology, today virtually anyone in the world can publish virtually anything for immediate consumption virtually anywhere in the world. That was a lot of virtuallys. That was 3. But it's true. Almost anyone in any country can publish almost anything for immediate consumption, and sometimes they go viral. Gorsuch and Thomas wrote this as they dissented when the court declined to take up a case. So they were hoping that the Supreme Court would take up a case where they would revisit this. So this is them indicating that if other cases come forward, they're likely to take it up. Nick Rekieta actually made a really good point in his video about this today, saying, do you remember when, like, duels were fought over reputation and honor and, like, reputational? And I was like, in my mind, I'm like, oh, Hamilton. Yes, I do. I do remember reading in history that people would fight duels over honor, over you can't lie on my name. And the standards the court is indicating maybe should be revisited to make it so that if you do say something that is false about someone that is reputationally damaging, you can be held accountable for that. Gorsuch went on to add that previous tests courts have used to determine seem increasingly malleable and even archaic when almost anyone can attract some degree of public notoriety in some media segment. That goes to who is and who is not a public figure. And so I think it will be very interesting to see. This goes on from Thomas to say that the proliferation of falsehoods is and always has been a serious matter. Instead of continuing to insulate, apologies, defamation, I went to insult, but insulate those who perpetrate lies from traditional remedies like libel suits, we should give them only the protection the First Amendment requires. True that. First Amendment doesn't mean you can wild out and say what the fuck ever. There are speech, but also consequences, slander and libel being some of those consequences. Thomas often plants seeds on issues he thinks should attract more attention from his colleagues. Oh, yes, he does. Thomas is like leaving the breadcrumbs of the direction he wants the court to go. And he's like, come on, everybody catch up with me, kids. Let's go. Let's catch up. So the rest of this article gets into the challenges of the case that was brought to the court that the panel declined to take up, but indicating that in future sessions of the Supreme Court, the First Amendment issue will absolutely be taken up. We have 2 more stories to cover in Court of Public Opinion. But before we get to that, tonight's stream has a sponsor. So if you will indulge me for just a moment, well, we have a word from our sponsor. A quick thank you to today's sponsor, June's Journey. June's Journey is a really fun, casual mobile gaming app that you can play either on iOS or Android, or even on your desktop through Facebook. It is a hidden object murder mystery game set in the 1920s, and you can download it completely for free. You know, I love a game. I am a total nerd, and I really enjoy some casual phone gaming. I do. And this is part of how I unwind at night, me playing games. Here's what I love about June's Journey. It is a detailed and beautiful game. And just like you enjoy digging into the details of cases that I talk about on this channel, in June's Journey, you're digging into the details to solve the crime of how June's sister was killed. Very scandalous. But unlike other mobile games, there's a lot to do, so it keeps you engaged with new challenges. And not only are you sometimes racing the clock to find clues and objects in the different scenes, but you also get to decorate the estate and upgrade and renovate. So there's 2 different components to this game that make it really compelling. I do find myself getting a bit competitive trying to beat the clock. I try to unwind, but then I'm like, no, I can find it faster. Where is that hidden in this scene? And it reminds me of like the hide and find book games that I used to play as a kid, which I very much enjoy. There's that nostalgia element, plus the beautiful animation and graphics in this game makes it a ton of fun. So download June's Journey today, give it a try, and let me know how you are going as your own law nerd detective solving the mystery of how June's sister was killed. Keep me posted. And thank you again to today's sponsor, June's Journey. So you guys, don't forget to download June's Journey. You can hit the link in my description. There's also a pinned comment. For those of you streaming on Facebook, I put a link in the chat, and I saw comments on the YouTube that the main character looks exactly like Courtney Cox. Right? I thought the exact same thing when I started playing this game. And I see a number of the law nerds already enjoy this game. I legit really enjoy this game. I do not take sponsorships on this channel unless it is something that I have used or enjoy. And I like games that keep me engaged, that aren't super hard and that are mobily accessible. I might also sometimes play when I'm in the bathroom. You know, I do play when I'm in the bathtub. So I enjoy it. Hopefully you will too. Hit the link down below. Thank you so much. Let's get back into it. I'm going to hit this super chat and then we're going to get back into our story. The next 2 stories are going to get a bit of a content warning, and that is why they got lumped together. Miranda Joy said, I'm so glad that Friday Night Live falls on my birthday. Happy birthday! I've had a crappy day, but this just makes it all better. Happy birthday to me. Everyone do the YouTube things. Happy birthday to you. That's about as much as I can get without getting copyright claimed by the estate of Michael Jackson. Have a good birthday. So yes, this is our first stream sponsor. Uploads have had a sponsor. I am hopefully going to bring you some other stream sponsors because it helps support what I do here. Truth. The California Superior Court charges a lot for documents. So it helps me continue to dig into the Britney case and get all into it. So let's get into the next two, a bit of a content warning. I am going to be talking about Allison Mack and NXIVM's sentencing and just a smidge about the Duggars because the court did, in fact, postpone the trial. I predicted that. I said the court's going to grant this motion. They did. I'm going to pull that up. These are difficult cases. They involve difficult subject matter. They involve really shitty behavior and shitty allegations of behavior. I hate the facts of both of these cases. I'm not going to be getting into the facts of them tonight. It is going to be a more lighthearted stream. It is going into 4th of July weekend, and the facts of these cases are both devastating. So we're not going to get into the facts too much. Thank you, chat, for respecting that. I very, very much appreciate you for that. Let's get into the Duggars first, and then we're going to get into Allison Mack. I actually pulled the sentencing memorandum from the court because I was also trying to explain or trying to understand myself why such a large sentencing departure. So I understand why a lot of the members said, can you explain what is happening here? So we're going to bring the facts on that after the Duggar. So the Duggars got canceled, first of all. Is anyone surprised about this? Were you surprised? Like, I was just waiting for this to happen, so I was not shocked. I know that this might upset the content plans of some creators here on YouTube that exclusively cover the Duggars, but I'm sure the Duggars will still do things in their private lives that will be covered. I don't know. Maybe not. Maybe it's like, okay, the show's done. We don't have to get into it. But after 11 seasons of Counting On, the network has... No, stop it. The network has confirmed that they are not producing additional seasons of Counting On, which means whatever has happened and it's done. I don't watch the Duggars. I don't know. TLC feels it is important to give the Duggar family the opportunity to address their situation privately. Let me translate that. TLC wants no part of this upcoming trial going on with Josh Duggar. There's no way to produce this show and not address it. So what we're going to do is not address any of it. A lot of you, and I love you for this, law nerds, a lot of you sent me links to Amy King's Instagram story where she was asking about NDAs. And I talked about it on another stream. I am going to talk about it here too. She was asking, like, if an NDA protects the show and the show's over, is the NDA over? Like, it seems that girl wants to just say what she knows, write a book, do the things. I think that that's something people would like to hear. But here's the thing about NDAs. NDAs can live beyond the thing that they're covering. So it depends on what the NDA is covering. Generally, NDAs cover information that may be, is confidential and private in some way. So depending on how an NDA is written, it can long extend beyond the end of a particular show. So even if the show has ended, the NDA can still live on. So that is a conversation for a lawyer who has the document in hand and can really explore the ins and outs and the boundaries of what can be said or what can't be said. Of course, some people's are like, NDAs, signed it, don't give a fuck, come at me, bro. I don't suggest that route. That's an expensive option to take. So it just really depends on what the NDA says. There are NDAs I've dealt with that say things like forever in time throughout the universe. So it's NDA'd literally forever. So depending on how this NDA is written, this could take some time. Classy Mom, thank you for the information, said TLC NDA'd with another reality star, John Gosselin. I actually know who John Gosselin is because I actually watched the Goslins. I'll tell that story another time. There was a reason I started watching the Goslins and then stopped many years later, but had watched, whatever, John and Kate plus 8. Reality star John Gosselin was 10 years from the end of the production, so I would assume it's the same more likely. It could be 10 years. It could have extended beyond that if they changed things or if the family requested things to be changed. But I think that's a good touch point, for sure. So it really just depends. And I'll be interested to see what comes of it. And I guess we'll see. So the Duggars got canceled. We're not surprised. Like, no one's shocked. It's like I think we were all just waiting for it to be formalized. It was like, have we done this yet? Like, are we there yet? Are we there yet? Are we there yet? Let's talk about this court order in the Josh Duggar case. We knew this was coming too. I said the court was going to grant it. There's no reason the court wouldn't grant it. As I pull up documents and then pull them down. What I talk about when I talk about protecting a case from appeal, and from my perspective as a former prosecutor in protecting a case from appeal, is doing the things that you need to do to make sure if you get a conviction that you don't Cosby your conviction. That's going to be a thing now. I'm going to make it a thing. Like fetch. It's going to be a thing. So you don't want to Cosby your conviction. You want to make sure that you do the things that you can do to protect your conviction on appeal. Most criminal convictions, especially substantial criminal convictions, get appealed. That is part of the criminal court process. So a court not granting a continuance in this case, I think, would open the door to appeal on the issue that the defense didn't have time to do a substantial computer forensic evaluation. And there's no mitigating interest to not grant this appeal. The government has had years to put together this prosecution. The defense can have some more months to do their forensic evaluations. No harm, no foul. No one's going to be hurt. The defense asked for it. There's no reason not to do it. Also, the courts are fucking backed up because of COVID. So the trial that was supposed to start July, whatever, has been continued to November 30th, 2021. Depending on how the defense goes with their forensic evaluation, I could foresee this getting bumped out again. The trial date, the original trial date, was July 6th, 2021, like literally next week. There's no way any of their forensics is done. There's no way. But that is the statutory timeline for trial. You have criminal defendants have a right to a speedy trial, and each jurisdiction has a timeline. Generally, it's pretty short to say, look, we can't hold you in custody. You have right to a speedy trial. But the defense has the right to say, I know that's our right. We would like more time. And the court generally grants it. So from July 6th to November 30th, the pretrial conference where they're going to check back in is November 18th. The defense might make another motion depending on what goes on with their forensics and say, hey, our forensics aren't done. We need a little more time. They'll have to show the court why they need more time and that they've been working. And that's what that is. So yeah, the trial got continued. I don't expect that we will see any more motions in court unless there's a discovery issue or unless something actually big happens. So we shouldn't really see much more. I will keep checking in on it, but I won't be surprised if we don't see anything else. Let's get on to NXIVM again. I'm not getting into the facts of this case. They're really dark. If you want to go down that rabbit hole, absolutely, on your own time, you do you. I just want to talk about this sentencing and why this sentencing was done. So let's get into actress Allison Mack. I was going to swoop. Something froze. I don't know what froze, but something froze. Allison Mack is an actress. I think she's most well known for Smallville. She was a part of the NXIVM cult that perpetrated some very, very serious crimes against women who were held against their will, extorted, forced to do things, all the things, if you think the thing, probably yes. And the sentencing range on this case was between 14 and 17 years. I want to talk about what that means real quick. In the courts, you generally get a sentencing range. States do this differently. The federal government does this differently, but you generally get a low, a medium, and a high, or a band where it's like from this to this. That is generally in place to keep justice equal. So if you're in California, just because you got convicted in LA County versus San Bernardino County for the exact same crime, given very similar circumstances, like, oh, we've got a robbery, it's a first time, there was a gun, but it wasn't fired, and you have no prior crimes, and you've expressed remorse, you get sentenced around the same time instead of one person getting 5 years and one person getting 50 years, because that would not be an equal carriage of justice. So there are sentencing guidelines to try to assist in keeping things within a similar realm. Now, courts can depart upward from the sentencing guidelines going, yeah, but fuck that shit. There's a lot of reasons to go upward. Like, what you did only gets this much time. And we saw this in the Chauvin case. You only get 15 years on this crime. However, there's all these other factors, aggravating factors, that push the sentence up and let the judge go above the sentence. There's also mitigating factors, things that can bring the departure down, saying the sentencing range is here, but because of these factors in mitigation, the sentence can come down lower than that range. Generally, those departures are not vast. This one was a big departure. This was a big departure. And I was surprised when I saw it, because the departure was so big and because she seemed to play a large role. I am going to talk about what the court said about her involvement in this scheme and her involvement in what was ultimately sentenced, which is racketeering and conspiracy. What it really was extortion and trafficking is what it was. I mean, that really simplifies the things, but part of why, well, let's get into what the court said about the departure. I'm going to get into 2 articles on this, and then I'm going to pull up the judge's sentencing memorandum, because I always find it best to just literally go to the source. The prosecutors in their sentencing, because there's sentencing memorandums from the defense and from the prosecutors, she pled guilty in 2019 and was just sentenced. She also played a key role for prosecutors in prosecuting Raniere, the tip of the pyramid in this big case. So the main dude got essentially a life sentence. He got 120 years for all of the shit that he did. She was a factor in helping them prosecute that. Assisting with prosecution can absolutely play into a departure in sentencing. And that's one of the things that happened here. She will serve, I had it written down and I'm not seeing it at the top of the article and I don't want to get it wrong. She will serve 3 years. I'm still kind of surprised. 3 years, a $20,000 fine, and 1,000 hours of community service. She was facing between 14 and 17 and a half years. So this departure is a large downward departure. The defense attorney said, quote, "In the last 3 years, Allison Mack has turned her life around and earnestly dedicated herself to rehabilitation, renunciation of Keith Raniere, the main dude in this who did get that 120-year life sentence, and those who supported him in making amends." Her lawyers wrote that she is now well on her way to once again being a productive member of society since being freed from the twisting influence of Raniere. And that was really the defense's argument, that she, though part of the people who were bringing women into this, part of the influence to victimize people, that she was also in part a victim herself. So even though she was a defendant, she was also a victim. So we will talk about what the court said about that in just a moment. Prosecutors noted the substantial assistance that Mack provided in their own sentencing memo and asked the judge to sentence below the guidelines. So both the prosecutor and the defense asked for it to be below. For me, I'm like, but 10 years is still below. Like 3 is really low. So we'll talk about the judge's reasoning in this, because 3 is low. And I'm sure that is frustrating to victims in this case. So let me pull up, as I pull this up and then pull it back down. all these links at the end of stream will be in the stream for the articles that are available. This article from Yahoo Entertainment was actually really well done, not spun, and it was just the fact. It was literally just the facts. It was like this. I've been finding alternative media to get just like what happened, because sometimes it's really hard to find just what happened. And this is a pretty thorough article about what happened in this sentencing. So let me pull up the judge's sentencing memorandum as to why this was the choice. Let me see if there's anything else I missed. She also spoke at this sentencing. So Mack wrote letters to the court and spoke at her own sentencing, and took fairly early responsibility, which is something the courts do consider most of the time when you take early responsibility. So we will pull up the court sentencing guidelines and sentencing and talk about why the court did what they did. Ultimately, is the judge wrong? The judge gets to make this decision. Does it feel low to me? It feels low to me. It does. It feels low to me. And the judge had some very strong words in here. So I was surprised that this sentencing memo reads like, you suck, you suck, you suck, you suck, you suck, but we're only doing 3 years. And I was like, wait, what? How, what? So let's get into it. The sentencing statement concerns defendant Allison Mack, who entered a plea of guilty on April 8th, 2019 on 2 counts of an 11-count superseding indictment. So they dismissed the other counts. So 9 counts were dismissed. She only pled to 2. She pleads guilty to count 1, racketeering conspiracy, and count 2, racketeering in violation of 18 U.S.C. 1962. I'm not going to deep into the charges. The statutory maximum sentence for these crimes is 20 years on each count. There is no statutory mandatory minimum. That's important to note. In a lot of cases, there is a statutory mandatory minimum. A mandatory minimum means no matter what, you have to do at least this much time if you are convicted. This case could have been a probation sentence with no custody time because there is no mandatory minimum. And that is in fact what the defense asked for in this case, was probation. Per the plea. Oh, I should also say, in the federal system, different than a lot of state systems, in the federal system, when a plea agreement is reached, the defendant and the prosecutor submit sentencing memorandums, but the judge ultimately makes the sentencing decision. In places like California, a plea is decided between the prosecutor and the defendant for an amount of time. And you go into the court and you're like, Your Honor, the parties have agreed that the defendant is pleading to these charges and the sentence will be this. And the judge can say, no, I'm not taking that plea, or tell me why you're offering this plea. And you make a record as to why that deal is appropriate. And this is what happens in like 90+% of criminal cases that they plea. In the state system, most places allow a defendant to plead open to the sheet, which is everything they're alleged to have done, and say to the court, I'm pleading open. I don't want to hear what the prosecutor has to say. Your Honor, I want the court to sentence me on this thing. In the federal system, all of the pleas, the charges you're pleading to, get worked out with the prosecutor, but then the court is the one that actually decides the sentencing. The prosecutor can't say, we'll give you 10. Do you take it? Do you leave it? No, that is up for the court to decide, which is an interesting quirk. I don't think I would like that as a federal prosecutor. I think, or maybe you do like it. It's like, I mean, we'll make a statement to the court. This is what we'll say to the court. These are the charges we'll let you plead to, but it's up to the judge. It's not up to me. Good luck. I mean, maybe it just takes some of the weight off of victims being mad at you for offering plea deals. I don't know. Per the plea agreement, the defendant admits to the following racketeering activity. 1, the extortion of Jane Doe 5 and Jane Doe 8. 2, the forced labor of Jane Doe 5 and Jane Doe 8. By labor, we all know what we're talking about in this case. Right. And 3, wire fraud of lower ranking members. She also stipulates to conduct underlying the sex trafficking of Jane Doe 5. There we've reached the demonetization threshold. YouTube, we're talking about facts. We have to be able to talk about criminal cases. Thank you. We're saying that it's it should not have happened. They calculated the sentencing guidelines, finding that the applicable guidelines range from 168 to 210 months, 14 to 17 years, being the appropriate level for someone with no prior offenses. They talk about how they calculate the sentence. And the court says, first, I reviewed the parties' sentencing submissions and listened to their arguments today in court. I want to commend counsel on both sides for their excellent work in preparing for this sentencing. I have read the 14 letters submitted in support of Ms. Mack, as well as 2 letters written by her herself, and I have listened carefully to her statement during today's proceeding. I have reviewed and considered the 6 victim impact statements that were submitted in writing and the 2 victim impact statements that were made on the record today. I'm sure that you can find reporting of what was said. I'm sure that that's out there. I have read 9 letters of apology that Ms. Mack wrote to the victims of her conduct. The court allowed her to send those. The court reviewed them before they were sent. I have also considered testimony adduced at co-defendant Keith Ranier's trial to the extent it is relevant and has been proven, in my view, by a preponderance of the evidence. It is well settled that the scope of sentencing judge's inquiry when analyzing the factors, and this goes into the law of what the judge is allowed to consider legally when it comes to a sentencing. And then the judge speaks directly to Ms. Mack. Ms. Mack, you pleaded guilty. It's rare that I see a sentencing memorandum written like this. I'm going to wander into prosecutor stories. There were a few judges that I quite liked that when they did sentencing, they would address generally the victims or the victims' families, depending on the type of case it was, and say, this is what I've heard from you. This is why I'm doing what I'm doing. I am sorry for what has happened to you. I am, however they feel about the case. And then they will look to the defendant and say, this is what you did. This is what I find that you did. This is what I think of it. I heard one judge was it Long Beach? I think it was Long Beach. Literally look at the defendant and be like, this is one of the most horrific cases that has come across my courtroom in my 30 plus years as a judge. I am disgusted by what you have done. And literally went in on the defendant and spoke directly to him. So it was very interesting to see in this sentencing memorandum, this speaking directly to her. You pleaded guilty to 1 count of racketeering and 1 count of racketeering conspiracy predicated on conduct that included forced labor, extortion, trafficking, and wire fraud. You admit to conduct in connection with your role as a first-line master. You will have to dig into this if you want to know more about all of the crazy and horrible shit that was happening here in the secret organization that included recruiting women to join the organization and requiring them to serve as your, quote, slaves. By many accounts, you were able to use your status as a well-known public figure to gain credibility. For me, this part, the using of a position of power and using celebrity to recruit people, seems to maybe not be a reason for a downward departure because we're using that power dynamic. But that's my opinion. You used your status as a well-known public figure to gain credibility and influence with NXIVM and DOS recruits. You abuse this position of power to persuade and pressure women to join. You capitalized on your celebrity and these individuals' eagerness to be close to you, told them you were recruiting them for a women's empowerment sorority, and misrepresented and obscured fundamental facts about the organization and conditions of membership. You told them that Keith Raniere was not involved. You did not tell them that they would be required to engage in adult conduct. You required your, quote, slaves to provide, quote, collateral, both as a price of admission and on a continuing basis in order to ensure their obedience and secrecy. Yeah, blackmail material. This goes on into some more disturbing details, which I have said I am not going to trigger everyone with tonight. I will, if you guys want me to, I will put this in a Google Drive and make the link public if you want to read it so that you guys don't have to buy it. Or I'll put it up on Scribed. We'll add it somewhere. He talks about using her leverage and goes on to say you used your leverage over these individuals and used your leverage to do these different, to do these kind of horrific things. This court in sentencing Mr. Raniere made it very clear how seriously it views the conduct for which he was convicted when it comes to DOS and the monstrous crimes he committed in connection with that organization. You were an essential accomplice. None of this says 3 years to me. You willingly enslaved, destabilized, and manipulated other women so that they were at their most vulnerable when they believed that they owed you total obedience. The court goes on to say, the victims of your conduct have described through their testimony at Mr. Ranieri's trial and through their letters and statements to the court the serious psychological and physical injuries that they've suffered at your hands. Again, this doesn't feel like 3 years. They have described your cruelty, your lies and manipulation, and your apparent sadistic pleasure in watching them suffer, and your creative enthusiasm. I mean, when it came to developing new ways to debase them. They have described enduring psychological trauma as a result of your actions. The court acknowledges that some of them, no sentence short of severe punishment would seem sufficient. Well, you had 17 years at least at your disposal. So, look, they have described enduring psychological trauma as a result of your actions. The court acknowledges that to some of them, no sentence short of severe punishment would seem sufficient, and that no sentence of any length can truly redress their trauma, which is true of most cases in the criminal justice system. The seriousness of your conduct, he goes on to say, and the harm that you have wrought dovetails with the need for your sentence to serve as a forceful deterrent both for you over the next many decades of your life and for others who may be tempted to use their privileges and authority to inflict harm and exert control over the vulnerable and impressionable. I mean, there are also important mitigating factors, 3 of which I want to emphasize. First, your lawyers make a persuasive case that you, like the victims of your conduct, were ensnared in Mr. Ranieri's coercive and manipulative web. I don't doubt that that is true. Like your victims, you turned over collateral in connection with your involvement in DOS. Like your victims, you were subject to abusive and unreasonable demands that were designed to destabilize you and deprive you of your agency. I don't doubt that you were also manipulated and that you also felt captive, even as you were inflicting those very consequences on other women. In the language of DOS, you were a slave as well as a master, and the harms you inflicted as a master were to some extent demanded of you in your capacity as Mr. Ranieri's slave. And that again is the language that was used within this organization. Second, you have expressed remorse and contrition and made significant progress towards rehabilitating yourself. And I see no reason to doubt your efforts and your progress are sincere. In contrast to other individuals who have remained deferential to Mr. Ranieri, even as the artifice of his virtues crumbled, the judge really does write very well. You have begun the hard work of unraveling the lies and grappling with your culpability and the consequences of your behavior. I don't doubt that it has been difficult and painful to dispel some of the illusions under which you were operating and attempt to see yourself and your behavior with a new kind of clarity. I commend you for having the courage to engage in that work. Your contrition and ownership of your actions cannot repair the damage you inflicted, but it is an important and encouraging step towards your own rehabilitation, which again is the goal of the system. Rehabilitation, not retribution. Third, you have assisted the government with its investigation and prosecution. The government described in its sentencing submission, you began to cooperate with their investigation approximately 1 month prior to Ranieri's trial. You provided key details about his role in DOS, including his solicitation of nude photographs and adult encounters. You turned to other evidence, including emails, documents, and audio recordings that became crucial pieces of evidence at trial in which Mr. Ranieri deserves the DOS branding ritual. According to the government, you were willing to testify at trial, though you were not called upon to do so. And the government takes the position that while you could have been even more helpful if you had begun to cooperate sooner, you deserve a sentence below the guidelines range. Conclusion, taking all of this into consideration, my task today is to balance the need for a sentence that adequately punishes the seriousness of your conduct and a need for a sentence that supports rather than disrupts your efforts towards rehabilitation. I've considered the range of sentencing guidelines that are available and the range suggested by the sentencing guidelines. I've considered the need to avoid unwarranted sentence disparities between you and other defendants who have been convicted of similar conduct. I have considered my obligation to impose a sentence that is sufficient but not greater than necessary to achieve the objects of sentencing. I agree with the government and your lawyers. A downward departure is warranted. A sentence even in the lower end of that range would be much greater than necessary. At the same time, for the reasons above, I believe that the nature and consequences of your offense need for deterrence warrant a serious sentence. And the judge considers at this point on count 1, a sentence of 36 months, and on count 2, a sentence of 36 months to be that appropriate sentence. For me, it feels low given the severity of what happened. But I have been involved in prosecutions, and I have friends that have been involved in prosecutions where circumstances are sadly not dissimilar to this, where someone who is a victim is also victimizing, and they are very complex cases because it is bad all the way around. So I can understand the court's desire. It does feel a little bit low to me. The court laid out their reasoning well. What they did is within the bounds of their duty to balance rehabilitation and retribution, and to really ensure this person will not reoffend. From everything that the court spelled out, it's clear that this person is not going to reoffend. This is not, that we are not concerned that this is going to happen again. This is someone who was pulled into something that was masterminded by something else. And though seemingly complicit in it, there are deeper psychological factors at play. And that's why the court did it. So that's the sentencing. That's the court's ruling. The court had strong things to say, but also took into consideration the cooperation with the government, the contrition, and the work towards doing something better. To that said, Raniere, the leader of the whole thing, is like, I will fight to the death. I have done nothing wrong. And Allison Mack was like, oh, no. This is all bad. Others that have been victimized of this, from some of the reports I've started to dig into, are still kind of under the corrupted mindset that has happened as a part of being a part of this. So I'm going to move on to a few super chats and to say hello in the chat, and then we'll get to the new court order for Britney. There are over 3,000 of you here. The paw nerds are yawning. We need a palate cleanser. I'm going to look at a few. This is heavy stuff, but this is what the criminal justice system does. This is what judges do day in and day out, is trying to balance those factors, even when it is very, very hard. So, Gil Gray said, for the OTAB booger in the back and your mods, thank you. Thank you very much. And appreciation to the mods. The mods have been working overtime for sure. We have been doing this. We have been riding this week for sure. Welcome as a new member, Tina. Natalie Lawyer Chick, hello. The sentence is low. I agree with you. Oh no, this is a concurrent sentence, Andrea. So this is a 3-year sentence plus the $20,000. It's good to see you, Natalie Lawyer Chick. It really is. It feels low. It does feel low to me too, but I can see where the judge is coming from. The way he describes what the victims went through, it's like, look, I know she went through it too, but also we've got to listen to the way the victims described it. And the victims described her as being a gleeful participant, I think was the words they were used. And that's kind of horrifying stuff. I know I missed a few super chats. I'm going to go dig those up real quick so I can say hello. So chat, I know. How do you guys feel? Do you feel it's too low? Like, how do we feel? How are we feeling? How are we feeling? How are we feeling about this? I feel, bleh. That's how I feel. I feel bleh. Like I get it, and I don't like it. That's how I feel. Bex N, I'm getting ready to go out for my 4th anniversary. Congratulations with the hubs. And I appreciate your company and the company of the awesome law nerds. That's what we're here for. We're here for community and to chat about the things that are hard and the things we don't like. Because it's okay to say it feels really low when you're facing 17. I mean, 7, 8 would have felt better to me. 4, like, I get it. I get that she was under his spell too, but 4, 3, it feels low. 7, 8, I would have been like, I get it. It's low, but I get it. George, why are we on the arm of the chair? All right, Jungle Cat, because Fred has stretched out all there, and George is just on the arm. So it just is. It just is. Cat B2 said it is very similar to a case in Mexico called Caso Andar. I'm going to butcher that. I'm sorry. Andrade, where a famous singer was also a victim, and it complicates and capitulates to other women's abuse, which is very hard. Meriden Emrys said, reduced punishment by reason of celebrity. Despite what the judge wrote, it has happened before. Sadly, it will happen again. And I feel that some celebrities, Lindsay Lohan being one of them, maybe got a little bit more sometimes than others would because of the attention on the case. But I think the use of a position of power should have carried a bit more weight, for sure. Sarah said, contribution for the demonetization. Thanks for the great content. You're welcome. Bearboo 1998 said, have you seen the Jordan Shanks versus John Barilino, I can't pronounce names, suit happening in Australia at the moment? I have not, but I've made a note. Miranda Joy said, I'm so glad that Friday Night Live falls on my birthday, and we got that. Hello, Rich Lux. Good to see you in the chat. So much drama. Shouldn't you be making videos about James Charles or something? I'm teasing. There's so much drama going on. Let me go and see. I bet we're already demonetized. I'm just going to peek because now I'm curious, but that's probably happened already. I'll go appeal it now, which I've learned from my friend Eric Hunley. Oh no, we're still in the green. Don't tell YouTube. We're still in the green. We're still in the green. We're still in the green. Ignacio said the sentence is extremely low. Were you able to find the Law Jokes book? No, I could not find Innocent, Your Honor. I am still looking for it. I hope to have it by Tuesday's stream. Last night on the live stream with the members only, I was looking for my book, Innocent, Your Honor, so that I could read part of it. And I couldn't find it. It wasn't on my shelf. So I'm going to find Innocent, Your Honor, and bring the lawyer jokes to the live streams, because if one can't make fun of oneself, and I am all for sometimes poking fun at my profession, there are those among my profession who deserve to be poked fun at. Because there are some lawyer things that are just like, fucking, are you kidding me? Which is it. So let me take a moment. I'm going to pull Pacer back up because I'm really curious if that Ron Richards opposition got filed. So here's what's going on in Girardi before we get into Britney real quick. I'll tell you what I'm looking for, and then I'm going to circle back to it because that's the way my brain works. In the Girardi case, Erica Jane's lawyers filed a motion to yeet Ron Richards out of the case after he was appointed over their objection by the court as the special prosecutor or the special litigator to go after Erica Girardi's estate and finances. Erica Girardi's attorneys went ham, and we talked about that. They called it they called the tweets vicious. That is up on the channel. They went wild talking about the way he had talked about Erica on Twitter, and asked the judge to reconsider this appointment and be like, no, it needs to go. And the opposition was due by 4 p.m. Pacific time today by the trustee. And I keep refreshing Pacer and it's not there. And I can't imagine after they filed the opposition in the other one, they wouldn't file an opposition to this, especially since Ron Richards told Page 6 that this was all bullshit. I want to see the opposition, but it's not there. It's still not there. So I'll come back to it. We're going to do Britney and then we will get back to it. Kim said, yes, the Australian case with @friendly Geordies is an amazing what is freedom of speech case. Good to know. It's always harder to comment on international law for sure. Matt Bond, I'm sorry I asked at the lawyer jokes. Not a worry. You've given me purpose to go hunt for that book. Motion to create an emoji to show love to the mods. Motion granted. Damn it, I don't have my gavel. I moved my gavels because I filmed a TV appearance and I wanted them to be in the background. And so I moved them. Motion granted. Motion granted. We will do a mod emoji. That didn't even wake up the cats. So motion is granted. Thank you. Thank you. There was something I had to see. Somebody said their baby just crawled for the first time. I saw it go by in my chat. I had to dip out. My baby just crawled for the first time. Sparks. Yay. Go baby, go baby, go. Also, if this is your first baby, let me just tell you something about crawling. It's so exciting the first time it happens. And then they are everywhere. and they're pulling up on things and they're getting into everything. And you're like, oh, they're everywhere. It's lovely. And it makes it feel like they're aging, and it's glorious. So congratulations to that. Let's get into Britney, and then we're going to see if this is filed. If not, we'll do a quick Girardi update and then just get to questions, because I've been talking forever. I always say it's going to be quick, and then the recap of the week always takes me way longer than I think it will, because I have no ability to account for how long things will take me. I do a very, very bad job. Like, my husband's like, how long will you be? I'm like, oh, 20 minutes tops. And like 3 hours later, he's like, are you done yet? I'm like, it hasn't been 20 minutes. My concept of time is characteristic of those with ADHD, because I have ADHD. All right, where did my court order go from Britney's new court order? I'm going to also talk a little bit about, I'll do a really short. There's been a lot of Britney content. I know you guys might not all be caught up, so I'll do a really short road so far with Britney. What's going on in the Britney Spears conservatorship is buck wild. Here's a brief recap, and I talked about this last night in a stream because so much happened. Literally yesterday, July 1st, Bessemer Trust asked to be removed as co-conservator of the estate. The court signed the court order on June 30th. The letters of conservatorship haven't even issued yet to Bessemer, so the appointment's not like final. They got appointed in November. Sam Ingham didn't file the paperwork till June 25th. The court didn't sign it till June 30th. And now Bessemer's like, whoa. Everything Britney said in court on the 23rd, she doesn't want to be in this conservatorship. We thought it was voluntary. This doesn't meet our definition of voluntary. Remove us. Today, the court was supposed to hear their ex parte. No, not supposed to. They asked for the court to hear their ex parte today. And the court said, negative, ghostwriter. The pattern is full. I am not going to hear your ex parte today, but we are having an evidentiary hearing on July 14th that I've already granted, which should be getting more news traction and is not getting any news traction. So I am going to yell about the July 14th hearing again in a minute. So today, what month is it? July 2nd, the court granted this order in part. And you will see the judge just, again, lined out the proposed. This is how you know when an order has been granted. The court lines out proposed, because I've seen y'all, not you, you're law nerds, you know what better. I've seen people posting proposed orders online being like, the court issued the order. Parties will file a motion and a proposed order because the judges require it, so they don't have to write the order. The judges don't want to write the order. The party that's making a motion files a proposed order. If the court grants the order, the court lines out proposed, makes any changes that are necessary, and signs it, which is what happened here. They had a typo that the court fixed. I wonder what it was. Judge of the Superior Court. There is something here that was a typo that the judge typed over. I think it was to insert her name. That's kind of funny. So this is from July 2nd, 2021, the ex parte application of Bessemer Trust Company to yeet themselves. Would that be yoted? No, that's past tense. It would be to yeet. To yeet themselves out of this case is not granted, but the court grants in part for reasons set forth on the following page. The time to hear petitioner's application for order approving petitioner's resignation, to formally yeet thyself from the co-conservatorship of the estate of Britney Jean Spears due to changed circumstances is shortened to the next court hearing for July 14th at 1:30. There is so much being heard on July 14th at 1:30. They have motions with regard to the finances. There's still objections over the hundreds of thousands of dollars the attorneys have spent. So that is still on the docket. There is an investigation that was granted. I'll pull that court order up in a second. The court granted an investigation into the things that Britney said on June 23rd based on her dad's motion. I thought her dad's motion was like at least 75% PR, but he also said the things Britney said are distressing. We should have an investigation. And the court was like, I agree. Let's have an evidentiary hearing with jury people. No, I'm teasing. It's a Legally Blonde line with actual sworn testimony to get into literally WTF is going on. I actually posted on Twitter that I would like the court to start the evidentiary hearing as follows. The bailiff would say, Come to order. Department 4 is now in session. And the judge would walk up and take the bench and sit down and look at everyone and be like, counsel, with all due respect, what in the ever-living fuck is happening in this case? This is how I want it to happen. It's not going to happen. That would never happen. I want that to happen. Counsel, with all due respect, what is going on in this case? Because when the judge says with all due respect, it means you all are idiots. I am angry. What have you done? When opposing counsel says with all due respect, it means that they are going to try to lay the smackdown next. So I have once said, with the respect that counsel is due, and then broke into laughing. It maybe didn't go over very well with opposing counsel. But it was exactly what was required at the moment. There was sometimes court sass. I'll have to tell the story about a judge that tried to sanction me for making a jury laugh another day, or maybe later today if we have time. It was a very funny judge, but he told me he was going to sanction me for making the jury laugh, and I told him it was not my fault that my face was funny sometimes. It was a moment. I was very nervous when that happened. I was not trying to make people laugh. Let's talk about one other thing I said I was going to follow up with Britney. Jamie Spears's petition for this motion that was granted. Look, the headlines have been court ignores Britney's request. Britney's denied her request. And we're not removing Jamie Spears. And I'm like, actually, the court granted an investigation into this case and no one is talking about it. Everybody's like, the court denies Britney. I'm like, who is spinning this narrative? Because the court also granted an evidentiary hearing, and that seems like a good thing. But no. Is that going to get as many clicks, TMZ? I don't know. Maybe not. Can we get that headline? I'd be happy to see it. I keep saying it. Maybe I need a blog. No, I don't need a blog. All right. I said it on Twitter. Well, I've said it enough. This is the response, Dad Spears' response to court-appointed counsel Sam Ingham's petition for appointment of Jody Montgomery as conservator of the person. PR. But there are two things that are said here. One, Dad Spears says in his petition to appoint Jody Montgomery, Ingham incorrectly states that, quote, the conservatee's incapacity to consent to any form of medical treatment was determined by order filed in this matter on 10/10/2014. I pulled up the orders from 10/10/2014, the ones that are publicly available. I didn't see any sealed orders. None of them say that, but none of them touch on anything about incapacity in those orders. So there could be sealed orders. I'm not saying there's not, but there is nothing that I can see that indicates on 10/10/2014 that an order regarding medical treatment was issued. From all the minute, I pulled up the multiple minute orders from that day. So that doesn't mean nothing's filed under sealed, but I went and looked because I said I wanted to look at what that order said, but the order is also not attached to this motion, which indicates to me that it could be sealed. Otherwise, they would just attach it here. I can go back into this petition another day if you guys are interested, and we can dig back through it. But this also asked at the end that based on the foregoing, Dad Spears requests that the court continue the hearing on Ingham's petition to appoint or set the matter for an evidentiary hearing requiring the personal appearance of the conservatee, Britney, so that the court may ascertain her true desires. So we need the court under oath to inquire literally what the fuck is going on. So let's pull up that court order so I can just reiterate again that I think it's a good thing that the court is having an evidentiary hearing. I do. I think it is a good thing. So let me get back out of this document, which is being temperamental at the moment. Is like, because my drive is like, why are there so many documents? And I'm like, I know it's a lot of cases. This file has a particular large amount because this case is so many years old. It's just a lot of stuff. Let me find the order granting the hearing. It was a good thing. Where is it? Here it is. So this This court order was issued on June 30th, but no, the signing of the denial is what made the news. But the court ordered a hearing to investigate the claims raised by Britney on June 23rd. That's a good thing. I want the court to investigate those claims. I'm very happy that they're doing that. You know how I'd like her to start proceedings. It's never going to happen. It would be completely inappropriate. I just think it's funny because I'm not in court and I can say things that I think are funny because in court can't be so funny. Out of court, allowed to be more funny. But funny to me anyway. I'm really happy about this court order. I'm sad that on the same day, the headlines were like, the judge ignores Britney's wishes to spin a narrative, in my opinion, from an order that happened in November, instead of saying judge issues and orders an evidentiary hearing to investigate Britney's claims. I feel like that's a good thing that's getting completely overlooked in this, but I am just one voice saying the things over and over and over. I shared that on Twitter too. No. Did it take off? No. Did anybody care? Well, some of you cared. It just frustrated me. You could see my annoyance with the media, which is why I love YouTube so much. I love the people can bring alternative voices and say, no, this is what I'm looking into and this is what I see going on. And I'm allowed to have that voice and bring that voice. I think it's a great thing. Let's real quickly talk about what happened in the Girardi case. There's not much. I'm going to get to questions and then I'll peek back in and see if this order got filed. I don't think it did. Quick Girardi updates. There's been a lot popping off in the Girardi Keese law firm side of the bankruptcy. All of Ron Richards' orders, Ron Richard being the special litigator appointed by the court for now, because there's a motion pending regarding it, he wants to know, how are you all getting paid and what can you tell us to help us find the money? Somebody's going to have to track down the money Erica is spending. I don't care who it is. Someone's going to have to do it. Someone is going to be in that position to do it. But he asked the court to order hearings, literally deposition style hearings and production of documents from her landlord, her family law attorney, her accountant, and saying, hey, you have to come to a deposition. You have to be sworn. You have to tell us what bank accounts money is coming from. And then they can go subpoena all those accounts and start to track down where this money is and try to find that alleged $20 million that has been transferred to her from the law firm of Girardi Keese. That money can then go back to Girardi Keese as a law firm and be distributed to the people that, should have been paid, his clients. Oh, there's also lenders and stuff. It also looks like the building has sold. That was approved a while ago, but it looks like there's actually a buyer to sell the building. The funds from the building will be distributed to the creditors in that case. And the motion to reconsider had a order. I'm going to pull up the order. I don't think I've pulled this up yet on stream because I don't think it was relevant. The motion to reconsider is Erica's motion to yeet Ron Richards off this case because of shit said on Twitter that they take objection to. Any opposition to the motion must be filed on or before 4 p.m. Friday, July 2nd, 2021. Well, it is 8 p.m. Central. What, 6:24 p.m. in the West? And it's still not in Pacer. Pacer's normally pretty fast with regard to documents. They normally populate almost immediately when they're filed. So I'm not sure if they didn't file. There's always a possibility that they file late. I'm just surprised that the trustee has not filed their opposition to the motion to reconsideration after it was called a vicious amount of tweets. But I'm in Pacer. There's a bunch of certificates. There's nothing. So the court said that they were going to consider this motion on the documents or decide if a hearing was needed. It would help if I just pulled this back up. Let me just, we're professionals. Let me just pull up the docket order and tell you what the court said. Any opposition should be filed like literally by now. Any reply to the opposition must be filed before 4 p.m. on July 9th. No further pleadings will be allowed, and the court will determine whether to set the matter for hearing after reviewing any opposition or reply, which means because there's no opposition, there can't be a reply to the opposition. So the court could rule on the pleadings or on the motion and say, yes, I grant it. No, I don't. I mean, it seems like rolling the dice. I think Ron Richards stands to, at a maximum, get 45% of what's recovered from Erica. So what's 45% of like 20 million? And then any costs. So that would be the attorney's fees. But if hard costs were spent, you would get your costs, your attorney's fees, and then costs. So this could be over what, $8-9 million. And so I'm surprised. I'm surprised that there's no opposition. Does it mean it wasn't filed? No. Does it mean that it just can't be delayed in PACER? It can always be delayed in PACER. I'm just surprised if it is, because PACER normally updates pretty quick. Of course, I will check in on it over the weekend and see if maybe after midnight PACER repopulates. But other cases that I'm following, the filings from today are in PACER. So we will see. If it updates, I'll update you on social media and let you know. But did they really not respond? Because right now it looks like they didn't respond. Did the trustee really just go, we think it's BS. You've already ruled on this. We're not saying anything. Or is the trustee like, the court's going to do what they're going to do. I'm not stoked about the Twitter either. Always a possibility that the trustee is also not thrilled. That's a possibility. And so the trustee gets to choose to respond or not. Wouldn't that be interesting? So I'll keep a look over this weekend. I'd love to know what you think about it. I have questions. You have questions. We all have questions. Let's get to questions. I have questions. I want to make sure I didn't miss any super chats. Debbie JF said, you should check out the Nigerian Yahoo boy. Ramon, I am Abbas. I am terrible at pronunciations. We talked about this in the members only stream last night, that it is one of the things hardest for me. So I try. Who was extradited from Dubai by the FBI for scamming, fraud, money laundering in the hundreds of millions, on trial this month in Chicago. I'll definitely take a look. That's right up my alley, because I am very, very I loved fraud cases. I did all kinds of cases at the DA's office. Fraud cases were some of my absolute favorite. Yes, they could be very sad. Yes, it was very hard for victims to recover the money that they lost, but tracking down, like the stuff Richards gets to do, tracking down the money and where it went is so interesting, because you get to be literally nosy as fuck, and you get to start digging through other people's bank records, and it's fascinating. Like, it's fascinating. I've told you guys about that case where we thought the guy's girlfriend was hiding some evidence. It was a money laundering case. They were laundering money through PayPal, which back in the day happened a lot more than it does now, but they were money laundering through PayPal. It was a pretty clever scheme, actually. I was like, oh, well played. Very interesting. So money laundering through PayPal. And there were some technological devices that we thought that the girlfriend had. The girlfriend happened to be a local news personality as well. And so we had all the jail recordings and him talking to the girlfriend. But then as we started going through the subpoenaed bank records and stuff, it turned out that the girlfriend was using his bank account to pay for a Match.com subscription. And the detective casually let it slip in a conversation with him. And he was like, she has this and she's got that and she's got that. And then his statement was like the foundation of a search warrant to go and get all the technology that she had, because we suspected it, but we didn't really know. But once he found out she was paying for Match out of his bank accounts, it was like all bets are off. It's just like there were detectives that would occasionally let slip if somebody on jail recordings was talking to both their girlfriend and or wife and their side piece and their other side piece. It was very, very, very interesting to see the different aspects of it. Susie Q said, someone posted that she rented her house in October. If that's true, doesn't that show premeditation with the separation divorce? Susie Q, this is a great question. She left November 4th. And what we've seen on the show, not that the show's evidence, because not sworn testimony, but what she said on the show was that she filed on election day because she thought that the election would be wild enough to cover it, that she had been planning how she was going to get out of this marriage. So yes, she was planning how to get out of this marriage. I don't doubt that. She said she was planning how to get out of the marriage. So with her planning how to get out of the marriage, she was, let me see if I can pull this up. She said that she filed it November 4th. Like, she dropped him off at work, said, bye, love you. And he was like, thanks, sweetie. And then said, and she said she felt like he was saying it to an employee. She went back to the Pasadena house with movers, got her shit, and left. No note. He was served with the divorce the next day. She was gone on November 4th. He was served documents. I mean, the news broke November 4th because either somebody got tipped or somebody saw it go up in the court system, but it broke that day. He got served the next day, and they have not spoken since. So yes, if she rented the house in October, she was planning on how to leave, but you can't leave November 4th if you don't have a rental. So she literally moved out, and I think she was starting to maybe move stuff in October, but she planned the separation in that she planned to leave. So that was it. Debbie Starrett said, have you heard Britney's audio from court that was leaked today? I mean, there's no other audio from court that could be leaked today. So I think I've heard her complete testimony, but the LA County court system has shut down their remote audio appearance for all cases because of that leaked audio. They're going to say it's because of COVID, but it's because of that leaked audio. The court was fucking pissed because I was on the actual court call, the court remote audio access, when the court said this. She was mad about the New York Times leak and then said, this is being recorded, shut it down. And the court shut down the entire system. Brenda Lee Lyndon Carpenter said 3,000 viewers, only 900 likes. We can do better. We can. I mean, I should start Nick Ricating and taking shots when we hit 1,000 likes. No, I shouldn't. It would be a mess. It would be a mess, but also let's go ahead. So Debbie, let me know what leaked today, because I don't think it's new. I think it's a re-upload. And that, I think I am caught up on super chats. So I'm going to get back into questions. And I appreciate you guys. Let's get into questions. We're going to do a quick court of public opinion at the end, but I wanted to leave time for questions because we've talked about so much this week. We've talked about so much. We've talked about so much this week. I saw a question that was a good question. Where was it? Darn it. It was, I'm sorry, Foxy Project. I know the reflection in the button. I haven't figured out how to turn it. I haven't tried that hard. I can do that. Amber, hello, Amber. Good to see you. Said courts turning off remote audio is like cops turning off body cams. We need transparency. We do need transparency, but when people break the rules, the court is not obligated, and the court has not sealed the courtroom. People can still go in person, people can still go in person unless the court starts sealing the proceedings, which will probably happen on June 14th. Britney's attorney, as I'm like messing with my face, apologies. Britney's attorney asked for future proceedings to be closed and future documents to be sealed. So we might be at the end of our transparency in this case. And I am worried about that very, very much. So I am worried. Let me see. I'm going to catch up on super chats. Let me see. We talked about that. Question, where is Lynn Spears in all of this? Lynn Spears has attorneys that keep showing up in court. They're currently fighting out the financial records. I have videos about that a month and a half ago, maybe more, about the objections to the financial records and how much Dad Spears is, I'm just going to call him Dad Spears. Dad Spears' team has been spending. So her attorneys have been in court as interested parties. So they have been showing up for sure. Rebecca said, this isn't my first Facebook. Well, I think you're on YouTube. Live chat ever. Thanks for creating quality content. Welcome, welcome, welcome. Yes, financial forensics is fascinating. And especially if you're kind of nosy. Money, you can follow money. You can follow money. Lynn said fraud was my favorite part of my accounting degree. It's fascinating. Question, could you cover in a future session what happened in Miami? HOAs have a lot of legal power. Heather, yes, I haven't gotten into it yet. I know they are still searching for people. So for me, it's a little close in time, but yes, as it gets a little further in time from the tragedy that happened in Miami, like I still can't wrap my head around it. And it honestly freaks me out. But it just, so yes, as we get a little further in time and the recovery is done, I will talk about it. Devil's advocate, is it possible that the conservator lied to Britney about how much power they had over her person? Anything's possible. Her attorney is supposed to be her advocate, to act in her best interest. Lying to your client is not within the bounds of your ethical duty, because a court-appointed attorney has like a fiduciary duty and a attorney ethical duty. And maybe 8 months ago, I would have said attorneys wouldn't just flout their duty like that. And then all the Girardi stuff happened. And I was like, what do I even know about the world and about how I thought? Most attorneys take their duties to their client very, very seriously. And if you guys love Natalie Lawyer Chick and watch her content, she talks about this in her content a lot, about how seriously that duty to your client, how serious that is, and how seriously you take that when you are literally the voice for someone. So I very much hope not. I was talking about this a little today on Eric Hunley's stream when Britney said, my attorney didn't, or I didn't even know I could file this document. I had more than a few cases as a DA where victims or victims' families would come to court and we'd be like, okay, this is happening today. And they're like, you've never told me that before. And I am like, I have literally said this every time you've come to court. But when people are under stress and they don't understand the proceedings, it can be very hard to remember that you were told something. So I don't take Britney's statement as Sam Ingham actually didn't do that. I took Britney's statement as she did not fully understand that she could do that. And there was a process for that. Yes, it's his job to help his client understand, but sometimes you just don't know what they don't understand and what they don't know. Because I've talked to people and they're like, you've never told me that. I'm like, actually, I've told you that every time you've come to court. And that can happen in any attorney-client relationship. So if Sam Ingham has been misleading Britney in some way, and if that is discovered, we have a really big fucking problem. I think the way that she feels and how trapped she feels is also a really big fucking problem. Question, what do you think about GOP members inviting Britney to testify regarding her conservatorship? They said her testimony on the hearing is alarming. Well, her testimony at the hearing was absolutely alarming. I don't really care what political party it is asking her to testify. This has been going on for a little bit. The members who signed that letter, and I shared it on Twitter, have asked or have talked about conservatorships before. I really think it is a disability rights issues and a civil liberties issues. Absolutely. Do I think Britney... I have questions about whether someone under a conservatorship can give testimony, like sworn testimony. Now, if they want her to make a statement and share her experience, I think that's different. But to give like sworn testimony, if she is still in a conservatorship, I don't know if legally she lacks or has the capacity to do that. And I have questions about that. She may. And my personal feelings are that after hearing her in court, she probably does. But I cannot medically say that because I don't know the medical records in the Britney case. Do I think that that's something that she wants to do? I don't know. Do I worry that politicians will just use the Free Britney movement as a pawn to be like, see, we're for the people? Oh, wait, I always worry about what the motives are of politicians. But I think there should be conversations about disability rights and about the power of conservatorships in the US and how they're used and the oversight in them. But ultimately, that's ultimately for each state to decide, not necessarily for Congress to decide how the states administer their probate courts. So I think it's a bit of a states versus federal government issue. Should there be some boundaries around that? I don't know if there aren't. I would have to look. I don't know if there aren't some federal guidelines that apply there. So yes. Angel, hello, good to see you. Question, what would happen if Ingham waited months to file termination paperwork like he did with the appointing of Bessemer Trust? And what could the court say for not letting Bessemer leave? Well, the court will need to hear what Bessemer has to say. because I also think that Britney doesn't want her dad in charge. And if Bessemer doesn't come in, her dad can't be yeeted out of this conservatorship. But the court is going to have to inquire with the lawyers, with Britney's lawyer, or with Britney herself, and with Bessemer Trust. Could Ingham wait months to file the termination paperwork? Yes. I'm wondering what's going on there. It seems, I have questions about this too, because you can't trust anything, but it seems that Britney is in Maui. So before that paperwork is filed, Ingham needs to sit down and have a conversation with Britney. But I think she left for Maui the day after this hearing, or at least that's what it was made to seem on social media. So if she's in Maui, they wouldn't have had that conversation yet because they need to have a conversation. Question, didn't Emily say we were going to get another DA story time about the bailiff breaking their arm or something? We talked about it last night on the members only live stream. I might talk about it again. I might. Question, can you explain what is currently going on with Johnny Depp and Amber Heard case? Stuff is happening. Britney stuff happened, and I have not looked into it yet. It is on my plan for Tuesday because I just haven't got. I'm just the one of the me still under the weather, and I have streamed all week, so I just have not gotten to it yet. So no, not yet. Allison said, is there a chance that Dad Spears PR could be trying to hide the granting of the investigation with the old court order that was denied? Anything's possible, but why? Like, I feel like he filed that motion to look like he was the good guy. Like, see, I'm fighting for Britney too. So why not say, see, I asked for the investigation and the court granted it and we're going to have a hearing. Maybe he doesn't want people to know there's going to be a hearing because he doesn't want people applying to go to court on the 14th to hear what's going to be said. Maybe it's that. Maybe it's that. Hello, Chris, multitasking, sitting in my living room, watching on my TV and also on Facebook with different accounts. Fun stuff. I'm going to try to sweep our other super chats and get to questions. Magsy, what the heckity heck is going on in the Spears case, right? They're juggling conservators and saying some things aren't true. Could Brit get pregnant if she has her own medical consent? If she has not had the power for medical consent, if she says, I want to go to the doctor, they should take her to the doctor. She has the right to make that decision. I think they should take her to the doctor. Anyway, they have the right to make that decision. I don't know what's going on. I have so many questions. I don't think they're juggling conservators. The Bessemer Trust, it was my hope that Bessemer Trust would come in and that it would allow Jamie Spears or Dad Spears to be removed down the road after Bessemer took over. It's a large, complex, functioning estate. I appreciate that. I was hoping Bessemer would give oversight and much needed investigation into what's been going on with Britney's money. I'm still optimistic that that will happen. Someone needs to look at these books and who has the resources to do so and the professional expertise to do so. I was hoping that that was Bessemer, and that would allow the road to be paved for Dad Spears to get out. I think that the pressing concern is not the financial conservatorship of the estate. I think it's the conservatorship of the person. You could remove one conservatorship and leave the other in place. That could happen. And I had hoped that the lawyers would focus on the personal restrictions that Britney finds so frustrating based on her statements and then deal with the money stuff. So with them not letting Bessemer leave, I'm hoping that the court will inquire and Bessemer will not resign. So it's been a while that Dad Spears has been the sole conservator of the estate. Before that, it was just an attorney, Andrew Wallet. So it was Andrew Wallet and Dad Spears were in charge. Andrew Wallet resigned and was allowed to resign. Dad Spears stayed in charge. They're trying to bring Bessemer in, and I hope they will bring Bessemer in and then let Dad Spears out. That is my hope. That is still my hope. Question, is it possible to demand just for emotional anguish? How much do you have to show for distress as YouTube trauma? I'm just curious. I love you anyway. Thank you. Cat B2, most states have causes of action for both intentional infliction of emotional distress and negligent infliction of emotional distress. Could statements made on YouTube by, I don't know, Gabby Hanna about someone like, I don't know, maybe Jesse Smiles, could you conceive Jesse Smiles maybe bringing a lawsuit for something like negligent infliction of emotional distress for the way that this has been drawn out? Perhaps that I'm using a fact pattern that I feel like we might all be familiar with, not legal advice. But yes, a lot of states have civil causes of action for both IIED and NIED. I talked about that a lot in the Toddy Westbrook versus KJ lawsuit because there were both of those causes of action there. Those causes of action often come with defamation claims because it's like, not only did you say this shit about me and like harass me on the internet, but also this was what it caused. It caused the infliction of emotional distress, especially when you see people saying, please stop. Question, what do you think about James Charles's return? Have you seen the video? I have not seen the video. I saw on Twitter, I was tagged by Kat Tembard when he took down the other video. And I said on Twitter, possibly after his video went up, but I did not know he had a video. I said on Twitter, is he pulling a Toddy Westbrook where he takes the video down and then pops back up? And it seems that he took the video down and then popped back up. I have not seen it. I have been doing all the other things. Oh, and we went to buy fireworks today. It's very serious business. I've spent almost every 4th of July of my life in Southern California. I spent one very interesting 4th of July in Washington, D.C. A lot of fun. But you cannot firework in Southern California. And as a prosecutor, I am not the one breaking the rules. That is not my bag as a member of the DA's office. So we did not light off fireworks because, things can go up in flames in California. It's dry. It is fire season. It is unsafe. I mean, including apparently LAPD bomb squad vehicles. But Tennessee is a very wet and green state and has very liberal laws with regard to fireworks. So we were out selecting and curating our fireworks for 4th of July. My children are very excited by the fireworks. Susie Q, also, the comment she made about the car was really bad. I'm assuming we're talking about Erica Jane and the Land Rover. I guess she had to downgrade to a Land Rover. Bad. She seems upset about the editing too. I don't know what Erica Jane's beef is with the editing. I think we've seen her show a little more emotion. I think some of it's genuine because she's trying to choke it back. Has Observe gotten onto this yet? Where are our body language channels? I want them evaluating Erica Jane, but it is hard when it's highly edited to evaluate the body language and the voice tremors. But yeah, I don't know. There was a lease of a Range Rover that was discussed in the bankruptcy, but I don't think it's the car she's currently driving. I'm sure they will be digging into how she paid for that car too. I'm sure that they will. So, question, do you plan on covering Elizabeth Holmes's trial? I have not decided yet. So I do not know. I have not yet decided. We will see. Question, am I to understand that someone is in the doctor exam room of Britney Spears' OBGYN? No. They shouldn't be. But the conversation can happen with regard to the medical conservator, the conservator of the person, and the doctor. So they have the conversation that the doctor sees Britney, but not that they are necessarily in the room. I don't know how that all plays. I've tried to stay a little bit out of that because it just feels so invasive and sad to me. Like it just did. Amber asked, where did her Lamborghini go? The Lamborghini was leased and the leases were all released within the conservatorship. So all of those leases were released. I talked about that a while ago because I was surprised all the cars were leases. I'm like, oh, none of these cars are owned. They were probably writing it off of their taxes and that's why they released. But I mean, I get it. We see the things that businesses write off in the latest indictments with regard to the Trump organization. Talked about that a little. I didn't really talk about it much on Eric Hunley's channel because I have not dove into that. But we see what people write off of business. I'm sure that the law firm was technically leasing all of those vehicles, and that with that they were being written off of taxes on the other side, which is what businesses do. Like that's what businesses do. Talking to spirits, laughing with ghosts. That is a fantastic handle. Tennessee, yes, we don't give a fuck here. I'm in Pigeon Forge. I want to go to Pigeon Forge so bad. We haven't been there yet. We have not made Dolly pilgrimages, but it will happen. It will happen. I'm lucky my dogs don't care about fireworks. I don't know if the paw nerds will care. So far, we've had some pretty rocking and rolling thunderstorms and they haven't seemed to notice. So I'm guessing that they don't care. Question. From J4, is it possible to pass evaluation with some mental health struggles that would naturally occur due to the way Britney's been treated, some PTSD, etc.? Is the legal standard of evaluation, or is it up to who the conservators hire? It's up to who the courts appoint. It's a checkbox. And I went through the checkboxes with regard to Tom Girardi. So it just depends. It's up to who the courts appoint. And it's up to the judge asking, like, this is what we're evaluating for. So there are different types of competency in court. Like there's competency to give testimony, which is different than competency under a conservatorship. The standard is and should be high, but the standards in California, they're literally those forms are check boxes. Like this person's not competent to care for themselves. And they've agreed. It's harder in a forced conservatorship. But by harder, I mean, it really depends on the judge and the doctor and the circumstances. And it sounds like Britney's been through quite a lot of evaluations that she found to be invasive and abusive, and she didn't like it. So yeah, Ashley Vincent makes a very good point. I dated a vet for a long time and fireworks triggered his PTSD. That is the case for a lot of vets. And I'm not surprised given that fireworks on 4th of July were meant to mimic the bombs that were flying in the Revolutionary War. That is literally the rockets, bright glare, the bombs bursting in air. So I am not surprised. And I know other vets that have had that experience as well, and that it can be very difficult. So I absolutely get it. Question, how do HIPAA and confidentiality laws coexist in a conservatorship? Well, it's the same as they coexist in a medical power of attorney. If you have medical power of attorney, you are the person who has the legal right to make medical decisions. So HIPAA doesn't apply because it's the same legally. It's the same. If my husband had medical power of attorney for me, him talking to the doctor legally is the same as me talking to the doctor before he took power of attorney. He has all of the rights that I would have had. Those rights extend to him now. So the rights, if they've been found, extend to the conservators. After what Jamie Spears said in his objection, I have questioned if if it was found in the conservatorship that Britney cannot make medical determinations here. Let me pull something up that maybe will help. Look, there's a caveat here. Your law nerds, I trust you to be responsible. The old conservatorship documents do not have that checked. I have not gotten through the new ones. I am pulling this up to show you what it looks like. Pull up Google Drive, pull up. So I'm going to pull it up to show you what those checkboxes look like. Where in my drive? I closed it out so that my stream wouldn't lag, and then. So let me pull this up real fast so I can show you what those checkboxes are. In the old ones, it's not checked. There are newer ones that I don't have. I'm going to make that very clear. There are newer ones that I have not pulled yet. So this is by way of example of the checkboxes that I would expect to see checked. And let me pull up these old letters of conservatorship from 2009. This is the person. And part of me is so torn about going through some of this stuff because Britney spoke so much about wanting her privacy, but also spoke about wanting the public to know what she's been through. So part of me is like, is this helping the public understand what she's been through, or is this an invasion of privacy? And so I struggle with some of these things, but I would like these questions answered. And I'm hoping that by looking through these old ones, I will find where it's checked and be able to say, see, the court actually checked this, not see, Britney thinks she has no rights, but actually she does have rights and somebody is not telling her the truth, because that's a very dark thing if that's what's going on. These are the old letters of conservatorship. There are new ones that have been issued. This is January 9th, 2009. This is granting James Spears conservator of the person. The thing is, we would get new letters if Jody Montgomery was formally appointed, but they are arguing over that July 14th. So name conservator, Britney Spears. And this is of the person. It's checked up here. I keep trying to focus in on this. I'm just going to have to wiggle my mouse, but that's checked up here. Other powers that have been granted, conditions that expose. This doesn't say exclusive authority to give consent for and require the conservator to receive medical treatment that the conservator in good faith based on medical advice determines to be necessary. That's not checked. So the forced treatment is not checked in 2009. This treatment shall be performed by an accredited practitioner of the religion whose tenet and practices call for reliance on prayer alone for healing, of which the conservatee was an adherent prior to the establishment of the conservatorship. I've never read through that. Interesting. If the court limits duration, this medical authority terminates on date. So it can be for a limited time with exclusive medical authority. Authority to place conservatee in a care or nursing facility described in Probate Code 2356. Authority to authorize administration of medications. These aren't checked. Powers to be exercised independently, attached, not checked. Conditions relating to the care and custody of the property under Probate Code Section 2402, not checked. Conditions relating to care, treatment, education, welfare, not checked. And then these are for limited conservatorships. And then this one at the end said, for limited conservatorship only, powers of the limited conservator of the estate under Probate Code, powers attached specifically in 3I. The conservator is not authorized to take possession of money or other property without a specific court order. And that is because the conservator of the estate has that right. At this time, it was also Dad Spears. And then these are the letters of conservatorship. And then there's extensive rights. But these rights in 3I are restrict and limit visitors, have the power to prosecute civil harassment. That was all the restraining orders against Sam Lefty. The conservator has the power to retain caretakers on a 24/7 basis and retain security guards on a 24/7 basis. The conservator has the power to communicate with treating and other expert medical personnel regarding conservatee and have access to any and all records except psychiatric regarding the conservatee's medical treatment, diagnosis, and testing. The conservator shall have access, subject to reasonable discretion of the conservatee's primary treating psychiatrist located in Los Angeles, to any and all records regarding the conservatee's psychiatric treatment, diagnosis, and testing. So that's at the doctor's discretion of what need to know. But that isn't forced medication. That's the ability to communicate, the right to communicate with doctors. That is not even like a medical power of attorney. So I don't know what's come next, but on these, it's not checked. Like this would be checked. It's not. So that was a long way of answering the question. I hope that answered. So this is an old document, and I have questions. Oh, Jake's Baby Cakes, it's so good to see you. I hope you are feeling well. It is good to see you, lady. I am glad you are here. So yeah, I mean, again, there are newer orders, and I am going through digging them up. Thank you, Maria, for the history lesson. History is not always my strongest suit. History Nerd Hero is the War of 1812, not the revolution that the anthem was based on. We didn't have a flag in 1776. I appreciate that. Thank you. Yes, I was conflating the two with regards to the fireworks being the rockets. So thank you. I'm sad. But I'm digging through these more deeply to try to figure out what powers are granted on the record if I can find them. That doesn't mean that there's not stuff filed under seal. Normally you see the motion to file it under seal, and then you know that something's actually been filed under seal. Allie C., do you think that we will ever find out the reason for the conservatorship in the first place? The medical reason? No, I don't. Unless Britney chooses to disclose it in a book or something later, I don't think we will ever know. Maybe we'll get her perspective on it, but those court records should not be unsealed. That is her privacy and her medical right to privacy. Amy Yost, hello. It's good to see you. I'm sure you're drowning in trials. Everyone's drowning in trials. COVID has opened up all the courts and it's a floodgate. I get it. Isn't the 3 being checked means that all of the below follows? Let me pull it back up. 3 being checked, I read it to mean, and let me double check it. I'm going to just pull it back up, that the attachment rights follow. So the medical rights should be checked represent Britney, but I could be wrong. And the reason I'm questioning it is because in Jamie Spears's motion to the court, he said her right to medical decisions was never taken away. So here's what it says. 3, other powers have been granted or conditions imposed as follows, and those are the conservator is not authorized and the attachment here, other specified powers are attached in 3I. So the seal's blocking it, but the other powers, you would check each of the ones that are granted. They only checked this one down here at the bottom under the seal, right there. And that is powers as specified in the attachment. And we read the attachment. So these are the other powers granted. And so this should mean that the only powers granted are these powers, not anything above, because those would all have to be checked independently. So, yes, this doesn't mean they're all checked. 3 means only 3J. I think this is a K down here. E, F, G, H, I. So this would be I down here. I4 is the only thing that's checked. Hopefully that answers the question. And hopefully that makes sense. I'm just going to leave this up because I'm probably going to refer back to it. Oh, she clearly seemed to think she can't make medical decisions. No, she clearly believes that she is not allowed by her team to go take out her IUD. She's clearly under that impression. All of us were under that impression that she does not have medical power. So I have to pull the newer ones to see if this changed. But originally, she did not have the ability for medical consent taken away. So we will have to see. No worries. I'm glad you asked it. Please ask. Always ask questions. Like we're here as law nerds to have conversations and ask questions. I will miss things. The more eyes on all of this stuff, the better. So please, 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 please ask questions. I am worried, Kathy at Oz, but her attorney has been her attorney for 13 years. He would know what the powers are. I don't know if some of these things are kept in the care orders because those are never publicly available. But you still have to grant the authority. So I don't know what else is under the care orders. And that's the only kind of caveat to all of this. So Jen B says, I feel overwhelmed. Same. Mooney Magu. Yes. Go ahead and like. We have 3K. We absolutely have 3K. Go ahead and do the likey, subscribing things. Meow though 9. Would you ever cover the contestant contract for RuPaul Drag Race and their extremely long NDA? Yes, I will. I have not pulled the actual documents, but yes, it's been on my list forever. And then all of this starts happening. Jen Welsum, have you ever considered teaching a class in law at a college? I have not, because in Los Angeles, well, a lot of DAs actually taught at my law school. Like people I went to law school with were then teaching back at my law school, which was kind of fun. But the commutes it killed all of that. But now that I'm in the Nashville area, there is so much here that I would absolutely consider it. I've done guest lecturing at University of Memphis twice now, and that's been really, really fun. I hope to keep doing that. I really enjoy their director of social media there, and I have gotten to know each other. And so I really enjoy guest lecturing in her classes. But yes, I like being a guest star. We'll be the guest. Just like podcasts. For years, I didn't have a podcast because I was like, no, I'm OPP. Other people's podcasts. Other people's platforms. Like I enjoy coming on and guesting. It takes some of the work out of it. But yes, it's something I would absolutely consider down the road for sure. Kyla said, hey, Emily, I'm so confused as to why Jamie Lynn Spears, confused. Was Jamie Lynn Spears ever part of Britney's estate? I think the statement made, she seems very sketchy. I am interpreting that you're asking, was Jamie Lynn Spears ever part of this? Yes. For a time, she was appointed as the trustee of the estate if something happened to Britney, meaning she would be like the executor of the estate, but not a conservator. So it would only be post-mortem if something happened to Britney that Jamie would be one of the executors of the estate, but that was changed a while ago. Nola Ray, if they did indeed lie to her, how would it be proven? I don't know. I don't know how it would be proven. There's so many lawyers looking at this. Like, there's just so many people looking at this. It's hard for me to think that she has been lied to more than it is. The clearer answer is she does not understand all of the boundaries of this. And I don't know why that is, but we're all still struggling to understand the boundaries. And if you don't understand court, some of this can be complex, and we're only looking at part of the story here because we don't know all the documents. But I can't think that many lawyers wouldn't be actually doing their job to do what's in her best interest. It just all seems really kind of sketch. And so the more eyes that are on it, the more I hope that we will see some truth. I hope, Alina, that they do investigate stuff from the whole 13 years. I still hope that Britney gets her own attorney to go back and look at this. I am hoping that Bessemer Trust comes in and at least looks at the finances and starts asking what the fuck's going on with the books to see what's going on with the money. Question: if her conservatorship is voluntary, is she legally required to pass an evaluation to get out of it, or can she withdraw her own consent? What is the legal meaning of voluntary? Jay, I would have to dig into some of the case law on it because off the top of my head, I cannot tell you. But could the court issue an evaluation? If the court believes it's in the best interest of her to order an evaluation, then they will. If her attorney says she needs to be evaluated for her own well-being before she's just, out of this conservatorship, then the attorney will ask for that, even if it's against her wishes, because that is her attorney's job, is to do what's in her best interest, even when it's against her wishes, which is a weird thing with conservatorships. But could the court say, you know what, you're right? Yeah, they could. Her attorney hasn't put it to the judge yet. Her attorney has not filed that and still has not filed it. So, question: has she been manipulated to think she has no power? Maybe. Or, and I hate to answer clearly because maybe that's the case, or maybe it is in later documents. Jamie Spears' dad Spears, his attorneys should know, his attorneys represented in a court document that it is not the case, that she does not have the ability to make medical decisions. And that has raised a lot of questions for me. And hopefully on the 14th, the court will be like, what we have here is a big fucking problem. We have Britney saying she has no medical autonomy, and we have Dad Spears saying that was never ordered. We have lawyer for Britney saying the court ordered this on the 14th. The court ordered it or they didn't. That shouldn't be hard for the court to sort out. I couldn't see anything publicly available, which leads me to believe some of that is sealed because it is in Sam Ingham's motion. And I will break those motions down because I will probably pull up where it says it in Sam Ingham's motion and juxtapose it with Dad's motion and put it up on Twitter and Instagram. So we just have it, or do a YouTube short on it, because it is a question that keeps coming up. And we're over 2 hours already. And look, the paw nerd is like, are we done yet? What, did you get hot? Did you get hot? Did you just decide to go to the floor because it was cooler? It is a little warm. Are we done? He's like, are we done here? Are we done here? I'm going to look one more time. Oh, there's like little lightning bugs going past my window. You guys tell me before we get to court of opinion, where you live, are they called lightning bugs or fireflies? And then we'll get to court of public opinion, just because I'm curious. Regardless, it's all sad. Yes. We all love Britney. Yes. So many questions. Yes. I hope everyone has a wonderful weekend. Happy 4th to all. Thank you. Talking to spirits and laughing with ghosts. I agree with you. It is sad. There are a lot of questions. The best we can do is to keep asking the questions and to keep saying why. And for those of us that have access to these records, to keep digging into these records, being like, what is happening? And I think that is a good thing. There's a lot of eyes on this now. So it's just like the federal government, right? The Twitter sleuths will find things. Sometimes they come to wrong conclusions, but Twitter sleuths will find things. And it's like, when the federal government puts their mind to investigate something, they'll just keep at it for years and years and years. Ask the Trump organization. So I'm curious to see if an investigation into this case is opened, just to see what's going on. But That would mean that the judge is doing shit wrong, her court-appointed attorney is doing stuff wrong, the attorney for the conservator of the estate's doing stuff wrong, the conservator of the estate's doing stuff wrong, the conservator of the person's doing stuff wrong, the conservator of the person's attorneys are doing stuff wrong, that Lynn Spears' attorneys haven't found it. There are so many different eyes on this, and there's so much information we don't know. It's hard for me to say something's wrong. There's a lot of questions here. I don't know if something's wrong. I know that I have a lot of questions, and I know that the problem is that Britney Spears doesn't feel safe, and she doesn't feel like the people who are supposed to be protecting her are protecting her, and that's something that needs to be fixed. Still no filing, by the way, in the Girardi bankruptcy case, and it is 9/11 Central Standard Time. Somebody asked me about Rachel Hollis's new video. I did not see it. I was asked about it on a podcast, and I was like, I haven't seen it yet. Oh my God, Emily recognized Brazil. I love Brazil. There's a case that I'm following in Brazil that I will talk about at another time because it's also kind of dark and we were doing light stuff. I love Brazil. And not just like Brazilian barbecue and like Brazilian jiu-jitsu, but I love Brazil. I have some friends that I very much enjoy who are Brazilian. Brazilians are fun. Lightning bugs, Atlanta. Fireflies, Minnesota. Ottawa, Canada. Fireflies mostly, sometimes lightning bugs. Don't you know? Lightning bugs, all eyes on us, as Britney was saying. Yep, all eyes should be on her. And it is. It's a motherfucking circus right now, but it should be. Lightning bugs in Kentucky. I was watching the Fireflies earlier this evening. So Fireflies for Jake's. Lightning bugs. Question, does anyone in a higher legal position have the power to investigate the judge, lawyers, and family? Not yet. It's really hard when politics, because like Congress in California can ask about what's going on, but it's really hard. Politics shouldn't be interfering in what's going on in the judicial branch. I'm sure there's been complaints made about the judge within the judicial branch. But it is, again, if I feel like if something was really wrong, Lynn Spears' attorneys are fairly new to this, that would be brought to the court. Lynn's attorneys have nothing to gain and or lose. They're being paid by Lynn. They're the only people not being paid by Britney. So I have a lot of faith in the women Lynn has hired to come in and be like, what's going on? But what we've seen is them objecting to the way Jamie Spears' team is spending money. And that is good. En español, vagalumes. I love that. I like vagalumes better. I might have to change what I call them. Lightning bugs, fireflies, both fireflies, lightning bugs, fireflies. I always called them fireflies until I moved here, and everyone here calls them lightning bugs. When I was visiting my friend in Tennessee and Oklahoma, I called them lightning bugs. Yeah, everyone here calls them lightning bugs. Both, but I like fireflies. I like fireflies too. When does she normally stream? Are we talking about me? I stream on Tuesdays at 11 a.m. Central and Fridays at 7 p.m. Central, normally for about 2 hours, sometimes longer. Do we trust Britney's latest boyfriend? I don't know. Uh-oh. Fred has said we're done. You know it's been 2 hours. Why are you so smart? Did you know you're the subject of our court of public opinion tonight? We should get to court of public opinion. Should we get to court of public opinion, buddy? Ugh. It's been over 2 hours. The mods have had a very long week. Mom's tired. It is kind of like pop and soda, what you call them. All right, let's get to court of public opinion. We're going to just do it. We're doing one. But I love hearing what other people call lightning bugs or fireflies. Thanks for putting your tail in my face, Bubbo. We're going to go to court of public opinion. Tiffany said the fireflies looked so neat at my work the other night. I work at a cemetery and they would fly up from the ground, flashing their butts and then stop. They do. When they first come out in the evening, coming up from the ground, it's so special. It's just such a cool thing. It's not something where I lived before that we had. I have family in Jersey, which is why I always say hi to Jers, but I have family in Jersey. And so when we would go visit in the summer, because we were those kids who left Southern California to vacation in Jersey where it was humid. And my grandfather's birthday was in August. So we would end up in Jersey in August. That's not the month to be in Jersey. when you're not prepared for Jersey. But finding the fireflies and the lightning bugs was always something as a kid that I have such good memories of. Also the donuts at the Jersey Shore, fucking amazing. Jersey knows how to eat. Look, Jersey has some amazing food. Jersey is good stuff when it comes to the food. Though there was a time, and then I'm going to get to court of public opinion. I said I was. We'll timestamp it differently. When I was trying to find a Starbucks, Jersey likes a Dunkin' Donuts more than a Starbucks in the area where I was. And I was trying to find Starbucks. I ended up paying accidentally like 2 tolls to try to get to Starbucks. And the Starbucks was in like a truck stop on the side of the freeway. It was wild. I was unaware how few Starbucks there were. And this was years and years and years ago, probably 10 years ago, trying to find a Starbucks. And people in Jersey would be like, just go to Dunkin'. What's wrong with you, you snobby California bitch? Just, why do you need a Starbucks? I needed Starbucks. I also maybe needed a drive for a minute. I didn't need to pay 2 tolls to get to Starbucks, but yeah. Oh, Jersey's all about Wawa. Fair enough. I loved Wawa. Wawa was the only place that we could find tasty cakes when I was a kid. Also, we went hiking was it last weekend? And we were cruising around east of us in Tennessee, and we actually saw a Piggly Wiggly. I was so excited. My kids are like, what's wrong with you? I'm like, there's actually a Piggly Wiggly. I was so damn excited. Let's get to court of public opinion. Court of public opinion. Look, people have told me lately that if you happen to die at your home, that your cats will eat you before dogs will. And I was like, but cats are the most amazing pets. So cats or dogs. We haven't done cats or dogs. I know this will be heated. Please be respectful of one another. I mean, and other people's wrong opinions. But cats or dogs, Ponards. I need to put a both in there because there are some of you that are both people. But cats or dogs. Cats or dogs. Cats or dogs is our court of public opinion tonight. But apparently, if you die, cats will eat you much earlier than dogs will. You would never. You would never. Oh, there's a bug in the stuck in the window. Go get it. So cats, dogs. You guys are like both. I will put both. I will put cats, dogs, and both. I see lots of votes for cats. I see lots of votes for dogs. Allie's like cat dog, obviously. Obviously. Cats, both but cats. I mean, Matthew, just own it. Just be like cats. Cats. I have a dog that's a cat in a dog's body, so both. I mean, that's fair. There's a firefly stuck between the screen of my window and my actual window that is making Fred crazy. Yeah, because he's flashing. Sorry, buddy. Starbucks doesn't do well here. There are 84 stores in Australia. Australia has really good coffee, though. So does New Zealand. So you don't need Starbucks. Look, here's the truth. I like a lot of the bakery items at Starbucks. I do not like their hot coffee. It's not good. It always tastes burnt. I like their cold brew. I like their nitro cold brew. It's amazing. But I do not drink their hot coffee. Like, I would not go get a hot latte at Starbucks. Because their coffee just always tastes, their brewed coffee always tastes burnt to me. Their espresso is a little bit better. Well, I guess espresso isn't a latte. I'm going to stop talking. It's been 2 hours. I'm tired. I'm tired. Oh, cats, dogs, cats. Yeah, do you want to put a vote in? You can put in a vote. You can say vote for me. Vote for me. No, you want to go. Okay. Back to the window. Thank you everybody for voting. Thank you. It's been a long week, y'all. We've covered a lot of topics. We will get into stuff on Tuesday. I will be on social this weekend, but probably not a lot. I am not working at all this weekend. I am not streaming. The courts are closed. The courts should be closed on Monday as well because 4th of July is on a Sunday. So it should be quiet. I am going to enjoy the 3 days. I hope you enjoy the 3 days. I hope it's quiet for you. Have fun. Be safe. Stay away from stupid people. Don't get punched in the face by Phil DeFranco. I need my own like outro. The outro of the podcast. May your Wi-Fi be strong. May your toilet paper be plentiful. May your families be well. And may the odds be ever in your favor. Have a great weekend. Thank you for being a law nerd. I appreciate you for being here. I will see you around the social medias at the Emily D. Baker. Bye. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube